There are three things that I and every criminal defense attorney that I know wishes everyone knew. And I want to talk about those things today. Those three things are that you should not talk to the police, you should not consent to searches, and you should call a lawyer early. So let me tackle each of those individually. First of all, don't talk to the police. What do I mean by that? Obviously, if you have to report a crime or you need to make a police report for your insurance purposes or anything like that, you have to talk to the police in those instances. But I'm not talking about those instances. I'm talking about the instances where you're minding your own business and the police come to talk to you. You don't know if they're coming to talk to you as a friend or as a foe. You also don't know how the officer is going to take the words you give them and either misinterpret them completely honestly or maybe not so honestly. If you provide them details and the details don't pan out, either because you don't really remember things as clearly as you think you do, which is very common, mind you, for anyone, because our memories are just not perfect. They're very fallible and malleable. So if you give them information that doesn't pan out exactly as you said it, that could lead to suspicion against you, or it could be used to strengthen the case that the police are already building against you. So you got to be very careful. The Constitution protects our right to remain silent precisely because the framers recognized that there is a terrible power imbalance when the government is asking you questions. We have the burden of proof that is laid squarely on the government's lap. The government has to prove guilt beyond a reasonable doubt, and the accused doesn't have to prove anything. Similarly, the accused does not have to participate in the building of the case against them. And so we all have the right to say, no, thank you. I will not be answering any questions. And I strongly encourage people to follow and apply that right because it's really the only way you can surely protect yourself. The moment you start talking, you're giving the police information that they can and will use against you. At the very least, you're locking yourself in. Say you talk to the police before you talk to a lawyer and you give a statement. Then you go talk to the lawyer and the lawyer asks you a bunch of questions. You might have very good answers to those questions, but depending on what the answers to those questions are, if you didn't mention that to the police earlier, bringing it up later is going to be problematic. They will use the fact that you didn't mention that sooner against you. Now, if you kept your mouth shut and talked to the lawyer first, the lawyer could have helped you develop your statement of what it is you need to say to the police and could have made sure that nothing was left unsaid if it was appropriate to share information with the government. And then they wouldn't be able to use your failure to mention something earlier against you. So when they say that anything you say can and will be used against you, they mean that very literally. The second thing I and my colleagues wish everyone knew was that they should not consent to searches. The Fourth Amendment of the Constitution protects a person's right against unreasonable searches and seizures. What is an unreasonable search or seizure? Well, it is presumptively unreasonable for a search or seizure to happen without a warrant. The most common exception to the warrant requirement, and really to the probable cause requirement as well, because a search has to have both probable cause and a warrant, generally speaking. The most common exception to both of those requirements is consent. If you give the police consent to come into your home and look around, they don't need probable cause and they don't need a warrant. Similarly, if you give them consent to search your car, they don't need a warrant, they don't need probable cause. Now, cars are interesting because generally you don't need a warrant for cars anyway, but they still need to have probable cause that there is some kind of contraband or evidence of a crime in the car before they can just go and search it. But if you give them consent, they don't have to explain at all what they thought they were going to find in the car. In fact, they might not have thought they were going to find anything, but you've given them consent. Consent completely shortcuts the process for the police, not to your advantage. Now, people might say, but Joel, I have nothing to hide. Why would I not consent? They're going to think I'm suspicious. That's going to drag things on even longer. I got nothing to hide, so might as well be on my way. Let them search and be done with it. Sure, why not? I'll tell you why not. Because you don't know if you're dealing with a good faith actor or a bad faith actor, first of all. You don't know if the police officer is looking for an opportunity to gain access to a part of your property that they would not otherwise have access to plant something. Now, I'm not saying that that happens commonly, but I am saying that I've seen it happen before. I have seen body cam footage of officers planting evidence. It does happen. So if you don't give them access to your home, they cannot plant anything in your home. So that's the first thing. The second thing is there is such a thing as the plain view doctrine. Once a police officer has a lawful authority to be in a place, anything that they see in plain view that is clearly contraband or evidence of a crime, they're allowed to seize. You might not appreciate all of the things that are in your home that can create problems for yourself. And so a quick, I got nothing to hide, that might not be true. Now you might say, Joel, I know I have nothing to hide. I don't have any contraband. I don't even have a beer in my house. Okay, great. Maybe you are sure that no one else has ever brought anything into your home that's not supposed to be there. Good on you. But here's the thing, you don't know. You never know. The only safe bet, the safest bet, is to not consent to searches. If the police have probable cause and they don't need a warrant, they're going to make the search happen anyway. If the police have probable cause and you don't consent, then they have to go get a warrant. Don't make their job to make your life harder any easier. The third thing that I wish everyone knew about their rights and how to proceed in the face of a criminal investigation is that they should call a lawyer early. Pretty much every week, I get to meet with at least one person who has been contacted by the police, and they haven't been formally charged with anything yet, but they meet with me to talk about what can this mean? What should they do to protect themselves? I love meeting with people in that way. I love it when people are proactive because I can do so much good by sitting down with the person and explaining their rights, their duties, and how to conduct themselves in order to not make the situation any worse. And the best outcome is when there's no need to hire me for formal representation because there's no case that's developed. I would much rather work with someone to keep charges from happening than work with someone to deal with the charges. As I was telling someone in a meeting that I had with them yesterday, I would much rather take a guaranteed acquittal with the risk of a subsequent arrest than avoid an arrest by guarantee, but have uncertainty as to what's going to happen with the conviction. So putting in the work on the front end can really help the outcome on the back end. And people often wait too long to contact a lawyer. I've had people who contact me after they've already had several court appearances. I mean, sure, I can get involved at that stage, and I'm happy to do so. But by definition, the impact I can have is diminished. The earlier I get involved in a case, the more positive impact I can have, the greater positive impact I can have on the outcome of that case. And so people often think, oh, let me see how this plays out. I'm going to go to court and I'm going to see how it is. I'm going to see what the offer I get from the state is before I decide if I want to hire a lawyer or not. Look, if your freedom and your liberties are that unimportant to you that you're trying to see if you can save some money by not hiring a lawyer, that's on you. But frankly, when they say that you're saving money for a rainy day, there's no day rainier than when the government is accusing you of a crime and trying to take your freedom away from you. I mean, I think I've said this on my channel before, but I'm like a tattoo. You get what you pay for. You want a free tattoo? Okay, just make sure you put it somewhere you can't see it. The better, the quicker you appreciate that it's not an expense as much as it is an investment in your future, the better your chances of having a good outcome with the assistance of a good attorney. So those are the three things. Don't talk to the police, don't consent to searches, and call a lawyer early so that your lawyer can help you out as soon as possible. I'm Joel Chorny. I'm a criminal defense attorney in Tucson, Arizona. This video is meant to be for educational purposes only. I'm not trying to create any legal attorney-client relationships with these videos. If you have an issue in Arizona that is a criminal matter, feel free to give me a call. If you have a matter that is in a different jurisdiction, make sure to consult with an attorney in that jurisdiction. Meantime, please subscribe, follow, share this video with anyone you think would benefit from it. And remember, you have rights. They matter. Protect them. Stay safe. And I'll see you in the next video.